A ruling from the state Supreme Court today could have a long-term impact on student safety.
The court ruled that schools do not need warrants to search some students. The decision comes from a 2019 lawsuit when a Denver high schooler said his Fourth Amendment rights were violated when the school searched his backpack and found a loaded gun.
Denver 7 reporter and attorney Jessica Crawford digging into this one tonight and has more on this decision.
Yes, so the Fourth Amendment is all about protecting people from unreasonable searches and seizures. It gives them a reasonable expectation of privacy. Well, today's Colorado Supreme Court decision applies to students on safety plans. Those provide special supervision to students who have certain behavioral concerns. Today's decision states that a school's need to maintain a safe environment can outweigh a student's expectation of privacy when they're on a safety plan.
On any given day at school, you'll find kids' backpacks filled with books or notes. One day in 2019, inside the backpack of a 10th grader at Denver's Kennedy High School, administrators found a loaded gun. Court documents show the student, referred to as JG by the court, was on, quote, a school-instituted safety plan that required daily searches of his person and belongings. The school implemented the safety plan after the student developed a history of criminal charges related to firearms. According to court documents, JG was searched and administrators discovered a loaded handgun in his backpack. The Colorado Supreme Court found the search was reasonable, and the school's need to maintain a safe school environment outweighed JG's diminished expectations of privacy in his backpack.
This decision doesn't just extend to DPS as a school district, but really extends to the entire state.
Igor Rakin is a civil rights attorney. He says the school didn't need a warrant to look inside the child's backpack. He points to the case that states for public school students searched at school, the usual constitutional protections requiring a warrant are replaced by a standard of reasonable suspicion.
When we're talking about a reasonable suspicion, you look at everything, including the kid's history, to determine whether the search was actually reasonable.
Parent Paul Ballinger joined the Parent Safety Advocacy Group after a 17-year-old student shot and injured two administrators at Denver's East High School in 2023. He calls the Colorado Supreme Court's decision a step in the right direction, but there's still work to be done.
I thought it was the right decision. I think that it needs constant improvement.
While Rakin questions why DPS students who have had gun offenses sometimes remain on generalized campuses and not in expulsion schools.
I don't know of any school district in Colorado that has the same kind of tolerance for kids with weapons as DPS does. DPS does not seem to be taking kids with weapons seriously enough.
We reached out to Denver Public Schools for a statement on the Colorado Supreme Court's ruling, but we haven't heard back at this time. Reporting in the studio, I'm Jessica Crawford, Denver 7.
Jessica, thank you. School safety plans were in the spotlight after the East High School shooting that Jessica mentioned. Just a year ago, that student who was under a safety plan shot and injured two school deans during his pat-down. Following the shooting, Denver Public Schools drafted a school safety plan. It was released back in June and included weapon detection systems, adding school resource officers and a modified pat-down policy.